You know, it is funny, but usually when we talk about a medical diagnosis, there is this expectation of just, well, clinical precision.
Right, like an X-ray or an MRI.
Exactly. You break your arm, you go to the hospital, and the x-ray shows that jagged white line right there on the black film.
Yeah, it is totally binary. Broken or not broken.
And you don't have to debate the existence of the fracture, right? Because
Yeah.
the technology provides this objective rendering of reality. The doctor just points to it.
Right. The machine does the arguing for you.
But then you step into the world of the courtroom, and suddenly that x-ray machine is, well, it's basically broken.
Oh, completely shattered.
Yeah, you as a citizen or a business owner or just an observer are suddenly looking at this landscape of degraded human memory, hidden motives, fragmented documents.
It is the absolute definition of diagnostic muddy waters. Because in a court of law, truth isn't just an objective reality floating out in the ether,
Right, it's constructed.
Completely constructed. Legal truth is entirely about what you can prove actually happened, according to a highly engineered, deeply skeptical set of filters.
Because the court assumes absolutely nothing.
Nothing at all. It demands a very specific format of reality before it will apply the force of the state to a dispute.
And that framework, that very specific filter of reality, is exactly what we are decoding today. Welcome to the Dope Dive.
Our mission today is to demystify the foundational mechanics of truth and proof.
Yeah, we are treating this deep dive as a masterclass. We are explicitly structuring this around the Unit 3 syllabus of an Osmania University law professor's course on the law of evidence.
Which is a fantastic framework to use.
It really is, and we are looking at the new statutory text of the Haratya Sakshatinyam 2023, the BSA.
Right, the massive overhaul that replaced the old Indian Evidence Act of 1872.
Exactly. So we are going to see how courts actually synthesize reality. We're talking about human testimony, expert opinions, relationships, and this is the big one, the battle between oral and documentary evidence.
Especially digital evidence. The shift from the 1872 Act to the 2023 BSA is just profound.
Because it is not just changing a few words around.
No, not at all. It is a legal system desperately trying to update its underlying operating system to handle the sheer volume of modern data, while also preserving these fundamental protections against fraud that took centuries to build.
Okay, let's unpack this. Because if we are going to understand how a court builds a picture of reality, we actually have to start by looking at what it deliberately ignores.
Not just a lot.
Right. Because a court simply does not have the bandwidth to forensically prove every single atom of the universe in every single trial.
Efficiency is really the lifeblood of the judicial process. The most efficient way to handle evidence is knowing exactly what you don't need to prove at all.
Right, skipping the line. And the BSA codifies a very clear principle under Section 53. Facts admitted need not be proved.
The logic there seems pretty straightforward.
Yeah, I mean, if two corporations are locked in a massive antitrust lawsuit, and they both agree in their initial legal filings that a specific merger agreement was signed on October 12th.
There is zero utility in the court spending 3 days calling secretaries and executives to the stand just to prove the date.
Exactly. The adversarial system is designed to resolve disputes. So where there is no dispute, the judicial machinery just powers down.
The system relies on the self-interest of the adversaries. Human nature dictates you don't concede ground in a fight unless it's undeniable.
But, and this is what I was wondering, looking at the course materials, what if the fight itself is fake?
That creates a dangerous loophole. What if the adversarial nature of the trial is a total illusion?
Right, because there is a crucial proviso attached to this rule. It explicitly says the judge has the discretion to require the facts admitted to be proved anyway.
Yes, the judge can veto the agreement.
So a judge can look at two parties aggressively agreeing on a fact and say, no, I don't buy it, bring me the receipts. In what scenario does a judge actually do that?
They do it when the agreement smells like collusion.
Give me an example.
Okay, imagine two parties orchestrating a fake lawsuit. Party A sues Party B, claiming Party B defaulted on a massive loan.
Okay.
And Party B immediately files a response, admitting to the default, and agrees to transfer a key piece of real estate to settle the debt.
On paper, it looks like a perfectly resolved dispute.
Exactly. But what if Party B is secretly nearing bankruptcy, and this entire lawsuit is a sham designed to transfer that real estate to a friendly entity Party A before legitimate creditors can seize it?
Oh, wow. So they are weaponizing the efficiency of the court to execute a fraud against people who aren't even in the room?
Precisely. They are using the court's rubber stamp to legitimize a theft. And the judge is not just a passive referee watching a tennis match. The judge is the gatekeeper of institutional integrity.
So if it looks like a fraud on third parties, the judge activates that discretionary power.
Right. They reject the shortcut. They demand actual hard evidence.
That structural paranoia really makes sense. Now, beyond facts that the parties just happen to agree on, there is another category of legal shortcuts, right?
Yes, facts the court is simply mandated to know.
The doctrine of judicial notice, sections 51 and 52.
Judicial notice is just an epistemologically fascinating concept.
It's like skipping the tutorial in a video game. You don't need to prove how to walk.
Right. It is the law officially declaring that certain truths are so universally established that demanding formal proof would be an insult to the intelligence of the institution.
The statute provides a highly specific list. The territory of India, the course of proceeding of Parliament, national flags.
And things that are just delightfully practical. The divisions of time, geographical divisions of the world, public festivals, the rule of the road on land or at sea.
It is the legal equivalent of a baseline operating system.
Exactly. You cannot run a trial if you have to litigate the basic parameters of existence every single time.
But I look at judicial notice and I see a massive potential for overreach.
How so?
I mean, I understand not requiring an astronomer to prove the sun rises in the east, but where exactly is the line drawn? Because what a specific judge considers, common knowledge might just be a reflection of their own socioeconomic bubble.
Oh, that is a very real concern.
Right. If a judge just knows that a particular neighborhood is inherently dangerous or knows that a specific industry operates a certain way, couldn't they bypass the evidentiary process and dictate the outcome based on prejudice?
They could, which is exactly the tension the drafters of the BSA sought to control. The boundary is drawn strictly at universality and verifiable public record.
So it's not just, does the judge know this?
No, the statute confines judicial notice to matters of public history, literature, science, or art. A judge cannot take judicial notice of a disputed local property boundary.
Or the specific behavior of a particular dog in a neighborhood.
Right, or the volatile stock price of a specific company on a random Tuesday. Unless it is a matter of unshakable historical record.
And there is a procedural safeguard too, right?
Yes, if a party asks a judge to take judicial notice of a fact, the judge can refuse until that party produces the necessary reference book or document.
So the judge can demand to see the atlas or the official government gazette. It is tethered to objective verification.
Exactly. Now, eventually, we move from verifiable facts to the legal realities established by previous courts.
Right, the relevancy of judgments, sections 34 through 36. If you are sitting in a courtroom today, when does a judgment from a totally different trial dictate your current reality?
The baseline rule is actually exclusion. Past judgments are generally irrelevant unless they involve the exact same parties arguing over the exact same issue.
The law wants every case judged on its own merits.
But there is a massive exception for judgments that fundamentally alter the legal status of an individual or an entity.
The BSA identifies these as final judgments from a competent court regarding probate, matrimonial, admiralty, or insolvency.
Right. And the key phrase here is that these judgments confer or take away a legal character. This is the difference between a judgment in personam and a judgment in rem.
Let's break that down for the listener. Because most litigation is in personam, right? It binds only the specific individuals involved.
Exactly. If you sue a contractor for botching your kitchen remodel and you win, that judgment only matters to you and the contractor.
It just creates a debt between two private parties.
But a judgment in rema, which means against the thing or against the world, is entirely different.
So if you are buying a used car, you don't care if the previous owner got sued by his plumber. But if you are buying a commercial cargo ship,
you desperately care if an admiralty court previously ruled that the ship was subject to a maritime lien and seized it.
Right. Or consider a probate court validating a will.
When a probate court declares a will valid, it isn't just resolving a dispute between two heirs. It is stamping a new reality onto the universe.
This document is the sole mechanism for distributing this dead person's assets, and that binds every bank, every property registry, everyone.
The same applies to a divorce. The court is dissolving a legal entity. If the court says you are divorced, you are legally divorced in the eyes of the global banking system and any future spouse.
So if your marital status becomes relevant in an unrelated lawsuit 10 years later, that past divorce judgment is conclusive.
Absolutely.
But there is a crucial caveat under Section 38. You can't just wave a past judgment around. if the process to get it was broken.
Truth in the legal system is structural. An adverse party can attack that previous judgment.
They can't attack the logic of the judge, but they can attack the process.
Right. They can prove the previous court lacked jurisdiction, meaning it was incompetent to make the ruling. Or, more dramatically, they can prove the judgment was obtained by fraud or collusion.
So if you bribed a judge in a foreign jurisdiction to get a favorable divorce decree,
You've poisoned the well.
and if the opposing counsel proves that fraud, the previous judgment just evaporates.
It ceases to exist as a legal reality. The system will not be bound by a reality constructed through deceit.
Wow. Okay, so we've established how the court skips the line. But eventually you run out of shortcuts. There's a dispute over raw, unrecorded facts, and the only way to reconstruct reality is human testimony.
We are stepping into the absolute foundation of the trial process, the strict rules governing oral evidence.
Sections 54 and 55, and this is where the evidentiary filters become incredibly aggressive.
The statute states that all facts, except the contents of documents, may be proved by oral evidence. But it mandates that oral evidence must, in all cases whatever, be direct.
The definition of direct here is totally uncompromising.
If the fact could be seen, the witness must say, "I saw it with my own eyes." If it could be heard, "I heard it."
If it was perceived by touch or smell, they must be the person who physically experienced it.
This architectural design effectively banishes hearsay from the courtroom.
It's a firewall against secondhand reality. Let's unpack why hearsay is so toxic, because outside the courtroom we use hearsay constantly.
We rely on it to survive.
Right. If my friend texts me, "Don't take the highway, there's a massive car crash," I believe them. But if that crash results in a lawsuit, I cannot testify about the crash.
You can only testify that your friend sent you a text. You are completely useless regarding the truth of the actual accident.
It's exactly like the childhood game of telephone.
Yes, I like to explain hearsay using the concept of lossy audio compression.
Oh, like an MP3 file.
Exactly.
Yeah.
Every time you copy and resave a heavily compressed audio file, data is permanently destroyed. The highs get clipped, artifacts are introduced. Human memory does the exact same thing to facts.
It is the degradation of reality through transmission.
When your friend witnesses a crash, their brain encodes a highly imperfect memory. When they describe it to you, they compress that memory into language, losing detail. When you hear it, your brain filters it through your biases.
And if you testify months later, the file is fundamentally corrupted.
But the degradation isn't even the primary reason courts hate hearsay. It is about the inability to test the data.
Cross-examination.
The ultimate diagnostic tool. Cross-examination ruthlessly tests perception, memory, sincerity, and articulation.
Did they actually see it? Have they retained the memory? Are they lying?
Right. And if the original witness isn't in the room, the opposing lawyer cannot run that diagnostic test. You cannot cross-examine an empty chair.
So if you are just repeating your friend, they can't ask you about the lighting conditions at the intersection.
Because you weren't there. Plus, the original statement wasn't made under oath, and the judge couldn't assess their physical demeanor.
So the law draws a hard line. The primary source must be put under oath. But there are exceptions. When is indirect oral evidence actually allowed?
The most dramatic exception in all of jurisprudence is Section 26, dying declarations.
It is a fascinating intersection of law and grim necessity. Statements made by a person as to the cause of their death are relevant, even if they didn't expect to die.
So if a victim is bleeding out in an alley and they whisper to a police officer, "John Doe stabbed me," that officer can testify to those words in court.
Even though the victim isn't there to be cross-examined, it is pure hearsay admitted to prove murder.
The historical justification was this old Latin maxim, "A man will not meet his maker with a lie in his mouth." The solemnity of death strips away the impulse to fabricate.
I have to push back hard on that premise.
Go ahead.
If we apply modern science, the logic fractures. You are dealing with someone experiencing massive blood loss, oxygen deprivation, their cognitive functions are crashing. Doesn't the trauma make their memory wildly unreliable?
We are trading the risk of a deliberate lie for the massive risk of a hallucination. That is exactly the tension defense attorneys exploit.
So why does the law still allow it?
Uncompromising necessity. If you exclude the victim's final words, you let killers walk free simply because they succeeded in killing the only witness.
Wow, it's a pragmatic compromise.
Yes. The hearsay comes in, but its weight is heavily debated. The defense can argue the victim was delirious.
Okay, so we've seen how the court handles human witnesses, but what happens when the direct evidence involves something the judge simply doesn't understand?
like a complex synthetic poison or a forged signature.
Right. Enter the experts, sections 39 through 45.
When the evidence exceeds common judicial knowledge, the court requires a translator. The BSA allows courts to rely on persons specially skilled in foreign law, science, art, handwriting, or finger impressions.
If a defendant claims they were legally insane, a psychiatrist maps the symptoms. If it's a rare poison, a toxicologist comes in.
But an expert cannot just walk into court, state their credentials, deliver a conclusion, and leave.
Section 45 says the grounds of the opinion are also relevant.
The phrase, "trust me, I'm a scientist," carries zero weight. They must expose the architecture of their conclusion, the microscopic striations on the bullet, the methodology.
What's fascinating here is how the Indian judiciary actually treats this testimony. I was reading the course materials, and there is a massive Supreme Court case, State of HPV Jailal.
Jailal is the foundational text. It strips away the illusion that science dictates legal outcomes. The Supreme Court declared that expert opinion is strictly advisory.
It is not conclusive proof.
It is merely one piece of evidence thrown onto the scales. The judge is not bound to accept it.
So let's construct a hypothetical, a high-stakes corporate fraud trial. The prosecution brings in a top-tier forensic handwriting analyst.
Okay.
This expert uses spectral imaging and testifies. This signature is a forgery, mathematically impossible for the defendant to have signed it.
The science seems bulletproof.
But the defense brings in 3 eyewitnesses, a public notary, a bank CEO, and a legal clerk. All 3 swear under oath, "We watched the defendant sign that paper."
We have a direct collision.
State-of-the-art forensic science versus human eyewitness testimony. Who wins under the Jailal doctrine?
Under rigorous application, the eyewitnesses will almost certainly defeat the forensic scientist.
That feels incredibly counterintuitive. We are taught human memory is flawed and science is objective.
But you have to understand direct perception versus inference. The expert is looking at the result of an action and guessing backward. The eyewitnesses are offering direct primary evidence of the action itself.
Assuming they hold up under cross-examination?
Exactly. If the direct evidence is deemed reliable, it overrides the expert opinion. The courtroom is an arena of legal truth, not scientific truth.
The judge retains the ultimate power. Now, what about sociological complexity?
What do you mean?
What happens when the court needs an opinion on human connections, like a relationship or a marriage, but the official paperwork is missing?
Section 44, the opinion expressed by conduct.
If the court needs to form an opinion on a relationship, the conduct of family members or friends is legally relevant.
The illustration in the statute is classic. If the question is whether A and B were married, the fact that they were usually treated by their friends as husband and wife is relevant.
You don't just have a friend say, "I think they were married." You demonstrate it. Did they share a bank account? Did they attend family naming ceremonies together?
The court looks at the behavioral footprint, and this ties into a massive doctrinal presumption in family law, explored in State of UPV Rajnarain.
The presumption of legitimacy in marriage. The Latin maxim pater est quem nuptia demonstrant. He is the father whom the marriage indicates.
The law generally presumes against vice and immorality. It prefers order. If a couple lives together for 20 years and raises kids, the law heavily presumes a valid marriage occurred.
It constructs a shield of legitimacy around long-standing social realities.
But here's where it gets really interesting. There is a criminal exception.
Right. This opinion of conduct is not sufficient to prove a marriage in proceedings under the Divorce Act or in serious criminal prosecutions for bigamy or adultery under the Bharatiya Nyaya Sanhita.
Let's pause on that contradiction. If the village treating them as married is good enough to decide who inherits a multi-million rupee estate,
why isn't it good enough to convict a man of bigamy?
it is entirely about the stakes. In a civil dispute over inheritance, the standard of proof is a preponderance of probabilities. 51% certainty moves the money.
But bigamy is a criminal trial. The state is threatening to strip a citizen of their liberty.
Taking away liberty requires a higher standard of proof, beyond a reasonable doubt. You cannot send a man to jail for bigamy just because the neighbors thought he was married.
What if it was just long-term cohabitation? The state must prove the strict ceremonial execution of a valid marriage to lock someone up.
The gravity of the consequence dictates the rigor of the proof.
Okay, we've covered oral testimony, experts, and sociological proof. But the law has a clear favorite child.
The king of proof, documentary evidence.
Ink, paper, and the best evidence rule. Sections 56 through 60.
The law harbors a deep skepticism of human memory. But a signed piece of paper is frozen in time, so it elevates documents to the highest tier.
Primary evidence is the document itself, produced for the court's inspection, the original.
And Section 59 dictates documents shall be proved by primary evidence except in specific cases.
Secondary evidence is the backup plan, certified copies, photocopies, or even an oral account from someone who read the original.
But you have to prove why you can't get the original first. You have to establish the chain of loss. Did the original burn in a fire? Is the adversary hiding it?
It's a massive anti-fraud mechanism, and this reverence reaches its zenith with the best evidence rule. Exclusion of oral by documentary evidence, sections 91 and 92.
Also known as the parole evidence rule. It is utterly ruthless in commercial litigation.
Let's walk through this. If a contract is reduced to a document, no oral evidence is allowed to prove the terms except the document itself.
And no oral agreement can be admitted to alter or contradict it.
It's the legal version of PIX or it didn't happen. Imagine we sign a 50-page commercial lease, rent is $10,000 a month, but before we sign, we shake hands and you verbally promise, I only have to pay $5,000 for the first year.
Okay.
6 months later, you sue me for the full 10 grand. I bring my buddy to court to swear he heard your verbal promise. I bring emails where you vaguely alluded to helping me out.
The best evidence rule annihilates your defense. The judge won't even let your buddy take the stand. The oral claim is completely excluded by the written text.
All hallway promises are legally vaporized the moment the pen hits the paper. Why is the law so merciless?
Because modern economies run on the predictability of contracts. If a written contract could be unraveled by someone claiming a secret verbal agreement, paper would become worthless.
But there are exceptions. You can bring oral evidence to show fraud or illegality or a subsequent oral agreement that modified the contract later.
The law protects the document, but won't let it become an instrument of extortion.
Which brings us to the digital revolution, because paper isn't just paper anymore.
How does the BSA handle the 21st century where documents are invisible code on a server?
The BSA explicitly includes electronic and digital records in its definition of a document. Emails, server logs, smartphones, WhatsApp messages, locational evidence, voicemails.
They're all legally documents.
But think about primary evidence. What is the original of an email?
The drafters resolved this ontologically nightmare with Explanation 4 to Section 57. Where an electronic record is created or stored simultaneously or sequentially in multiple files, each such file is primary evidence.
Wait, that is mind-bending. The file on my laptop, the file on the server, the file downloaded to your phone, the law says they are all primary evidence.
Digitally, a perfect copy is mathematically indistinguishable from the original, so the law adapts.
But wait, if a digital file is primary evidence, what about manipulation? How does the law deal with edited screenshots or deepfakes? Doesn't the best evidence rule struggle when a forged PDF is mathematically pristine, has no eraser marks? I can just change the payment to $90,000 and hit save.
This is exactly what keeps appellate judges awake at night. The ease of digital manipulation fundamentally threatens the courtroom.
So how does the BSA handle it?
The admissibility of electronic records requires strict foundational proof. You cannot just hand the judge a WhatsApp screenshot. The courts must authenticate the digital file using digital forensics.
Bringing in metadata and hash values.
Exactly. Hash values are critical. A hash value is a cryptographic fingerprint for a digital file. You run a file through an algorithm, and it spits out a unique alphanumeric code.
And if you alter a single pixel in a video, the hash value changes completely.
It is the ultimate tamper evidence seal. When police seize a hard drive, they generate a hash value. Years later at trial, they hash the file again. If it matches, they have mathematical certainty it hasn't been altered.
So we are replacing physical permanence with mathematical permanence.
We have to, because social media posts and Slack messages are often the definitive proof now.
Now, authenticating every single file takes an immense amount of time. Which brings us to our final mechanism, streamlining truth through presumptions as to documents.
Just like judicial notice, presumptions let the court skip proving the authenticity of highly reliable documents.
The ASA categorizes these into may presume, shall presume, and conclusive proof.
Let's define the terms. May presume means the judge has discretion. They can accept it as proved or demand proof.
Shall presume is a hard directive. The court must regard it as proved until it's disproved.
And conclusive proof shuts down the debate entirely. You aren't even allowed to bring evidence to disprove it.
Sections 79 through 81 rely heavily on shall presume. The court shall presume the genuineness of the official gazette, newspapers, and documents directed by law to be kept.
It shall presume the execution of a power of attorney if authenticated by a notary public.
If we connect this to the bigger picture, why is this so essential?
To prevent the legal system from collapsing under its own procedural weight. Imagine a corporate fraud trial where you need to authenticate 50 notarized powers of attorney and 300 Gazette notifications.
You'd spend 4 years just subpoenaing notary publics and newspaper editors before the trial even started.
Exactly. The law acknowledges that officially stamped documents carry a vastly higher probability of authenticity. It shifts the burden of proof violently onto the defense. If they think a notary was bribed, they have to prove it.
Wow. Okay, we have deconstructed an immense amount of legal architecture today.
We really have.
We recapped the Osmania University Unit 3 masterclass journey, from judicial notice what we don't need to prove, to the strict rules of direct oral evidence and hearsay.
We covered the advisory nature of experts and the absolute primacy of documentary and electronic evidence over oral claims.
You, the listener, now have the mental framework of an evidentiary gatekeeper. Next time you're in an argument, ask yourself, is this direct evidence, hearsay, or an expert opinion?
Do we have primary documentary proof or just an oral claim contradicting a written text?
It fundamentally rewires how you interact with reality. So, what does this all mean?
Well, I want to leave the listener with a final thought. The Horatia Saksha Adhiniam is a massive update, specifically bringing digital messages and locational data into the realm of hard evidence.
Right.
But consider this. Technology is accelerating. As generative AI advances, generating hyper-realistic, completely fake video and audio that looks and sounds like direct evidence.
Deep fakes.
Yes. Will the law's deep reliance on seeing is believing and digital files or primary evidence hold up? Or are we going to need an entirely new legal paradigm to determine what truth even is when reality itself becomes synthetic?
That is an epistemic crisis to keep you up at night. Keep questioning the structure of reality, keep testing the evidence, and keep diving deep.